63. The appeal is dismissed. I have considered the issue of costs, and in this circumstance, there should be an order of $500 costs to the respondent. In the District Court at Auckland. CIV-2024-004-002220. 2025 NZDC 8107. Between Graham Wessels, Appellant, and Central Car Company. Respondent. Hearing, April 14, 2025. Appearances, a Nair for the Appellant. J. Murphy for the Respondent. Judgment, April 16, 2025. Decision of Judge D. Sharp. Introduction. 1. Mr. Wessels appeals the decision of the Motor Vehicle Disputes Tribunal, MVDT, dated August 15, 2024. 2. The case was brought in relation to a 2008 Land Rover discovery, the Land Rover. 3. The appeal is on the grounds that there was an error in the application of the Consumer Guarantees Act 1993 and a failure to properly assess the evidence presented. 4. There is jurisdiction for the court to consider: A. Was the decision wrong in fact? B. Was the decision wrong at law? And C. Were the proceedings conducted by the tribunal in a manner that was unfair to the appellant and prejudicially affected the result of the proceedings? Background. 5. On February 4, 2023, the appellant purchased the vehicle from the respondent for $13,995. At the time of purchase, the Land Rover had traveled 247,978 kilometers. 6. The appellant referred to written submissions filed. Counsel for the appellant particularly referred me to text communications where the following exchange was recorded. Appellant: Great, I work across the road and should be in tomorrow. Respondent: I am using the vehicle so it needs a clean but he goes perfect. Appellant: All good if it's dirty, I will look at structure etc. What mileage? Respondent: 246 kilometers with full history, 1 owner, NZ new, tow bar, Java black. Appellant: Great, I am definitely keen. 7. The appellant also relied upon the suggestion of one New Zealand owner which was a false representation. Further, that the words "but he goes perfect" were a representation as to the Land Rover's performance that was untrue. 8. The appellant submitted the MVDT has erred in its interpretation and application of the Consumer Guarantees Act 1993, specifically in determining the Land Rover to be of an acceptable quality. Law. 9. Rule 18.19 District Court Rules 2014 provides that appeals are by way of rehearing. 10. Virtually all appeals to this court are determined on the evidence given before the body appealed from, with power to rehear as to part or whole. This court, on appeal, makes full allowance for the fact that the decision-maker had the benefit of seeing and hearing the witnesses, and will only disturb the findings if it can be shown that the decision-maker exercised his or her discretion on some wrong principle, or disregarded a relevant consideration or took into account an irrelevant consideration. Shot over Gorge Jetboats Limited v. Jameson. 11. The Supreme Court in Austin, Nichols and Inc. v. Stitching Lodestar, held that on a general appeal the correct approach for an appellant court is to form its own assessment on matters of fact and the law. The court may come to a different opinion than the court or tribunal appealed from. If the original decision is wrong, the court is obliged to overturn the decision. 12. The court went on to hold that an appellant court may overturn a decision even if made by a specialist body such as the Motor Vehicle Disputes Tribunal. The appellant court is not required to give any particular weight or pay deference to the views of the expert court or tribunal, although it may consider their views carefully. The appellant court is obliged to form its own assessment of the issues at hand, irrespective of whether the court or tribunal appealed from is one of general or specialist jurisdiction. 13. The Fair Trading Act provides that no person shall, in trade, engage in conduct that is misleading or deceptive or is likely to mislead or deceive. While there can be slightly different approaches to applying this legislation, a first step can be the consideration of whether a reasonable person would be likely to be misled. This will involve a consideration of the transaction and circumstances that surround it. Also, there is a question to be answered as to whether the person was actually misled or deceived, which is critical link between the conduct and loss. If a person was not misled or deceived, any loss or damage they suffered is not attributable to the misleading or deceptive conduct but to some other cause. For a person to be misled or deceived, they must do or not do something. Identifying a loss or damage caused by the misleading or deceptive conduct involves inquiry as to what the conduct caused the plaintiff to do or not to do and what consequences flowed from that. GSE Group Limited v. Walters Supplies Limited. 14. The third question is, if a person was actually misled or deceived, it is then necessary to consider whether the conduct was the, or an effective or operating cause, of the claimant's loss or damage. 15. A court may only make a remedial order under S43 of the Fair Trading Act if it finds a person has suffered, or is likely to suffer, loss or damage by conduct of any other person. The decision. 16. The appellant claimed $5,058.45 from the respondent. 17. The tribunal saw the issue as to whether the vehicle was of an acceptable quality for the purposes of S6 of the Consumer Guarantees Act 1993, CGA. 18. The tribunal considered that the issue of whether a vehicle was of acceptable quality was from the point of view of a reasonable consumer who was fully acquainted with the state and condition of the vehicle, including any hidden defects. 19. The defects which the appellant listed were identified. It was acknowledged by the respondent that the transmission for the vehicle required repair. But the respondent says the transmission was repaired and the appellant acknowledged that the symptoms complained of ceased upon repair. The appellant alleged other failures in respect of the vehicle. A CV joint failure. B. A wheel bearing failure. C. A loss of oil and coolant, suspension problems, and white smoke, and D. Alternator, EGR and catalytic converter malfunction. 20. The respondent claimed that the appellant either attempted repairs himself or engaged a mobile mechanic, who had provided no details recording diagnosis and repair. 21. The respondent argued that it was not given a reasonable opportunity to repair the CV joint failure. Likewise, the respondent submitted that repairs to the wheel bearing were carried out without reference to the respondent. As regards the suspension, leaking oil, smoke, and coolant, the respondent argued that those symptoms took place some 6 months and approximately 10,000 kilometers following the purchase. 22. The respondent's submission was that repairs and maintenance could be expected for a vehicle of that age and mileage and that the presence of such defects were not in breach of the requirements of the CGA. 23. The MVDT had the benefit of an expert assessor, and the following reasoning was applied. 25. The purchaser of a 16-year-old European vehicle with an odometer reading of more than 250,000 kms should have realistic expectations as to its quality and durability and should understand that the vehicle is likely to have pre-existing defects consistent with its age and mileage or can develop defects and require ongoing maintenance of a sometimes unplanned and expensive nature. Here, the trader has attended to the transmission amongst other issues initially. However, a reasonable purchaser would also understand the supplier's obligation under S6 of the Consumer Guarantees Act 1993 are finite and, at some point, the risk of the vehicle developing defects must transfer from the supplier to the purchaser. The point in time at which that risk transfers is determined with reference to the factors in S7, 1, F, 2, J, of the Consumer Guarantees Act 1993. Appellant's submissions. 24. The appellant submits the tribunal failed to adequately consider the representations that were made prior to the sale of the vehicle and that the appellant was prejudiced. 25. The submission is made that S7 of the CGA does not exempt older or high mileage vehicles from the requirement to be of acceptable quality. 26. The submission is made that a reasonable consumer does not expect to incur major repair costs immediately after purchasing a vehicle, regardless of its age or mileage. 27. The appellant further submits the respondent breached S9 of the Fair Trading Act 1986, FTA, by engaging in misleading and deceptive conduct. 28. The appellant points to S43 of the FTA as providing extensive options for compensation for the appellant. 29. The appellant submits the MVDT failed to properly assess the evidence of defects presented by the appellant. 30. The submission is made that the MVDT's conclusions that the issues with the Land Rover were consistent with the vehicle's age and mileage were contrary to the evidence. 31. And the appellant submits that under CL 16, 4, Schedule 1 of the Motor Vehicle Sales Act 2003 the conduct of the hearing is submitted to have prejudicially affected the appellant in that the decision does not consider the factors listed. 32. The appellant submits the MVDT failed to apply the CGA and as a consequence prejudicially affected the appellant. 33. The appellant seeks remedies in relation to compensation for the purchase of the Land Rover, compensation for costs in remedying the condition of the Land Rover. At hearing, the appellant made the point that if the court were to order compensation to the appellant in respect of the purchase price of the Land Rover, that would remedy the damage that the appellant has suffered. Submissions of the respondent. 34. The respondent submits there were no errors of fact made by the Motor Vehicle Disputes Tribunal. Also, that there was not any allegation at the MVDT of a breach of the FTA. 35. The appellant has not provided evidence of a clear nexus between alleged misleading conduct and the alleged loss or damage to the Land Rover which would allow the application of S43 of the FTA. 36. As regards factual findings, the respondent firstly submits there was no error of fact. Secondly, it points to the assessor's personal attributes, qualifications, skills, and knowledge of, or experience in, matters likely to come before the MVDT. 37. The respondent submits that there was no reasonable opportunity to repair alleged defects with the Land Rover, despite communication attempts. Further, the factual findings made involve an assessment of the appellant's credibility. The respondent submits courts should be slow to interfere with credibility findings of a first-instance decision-maker. 38. The respondent notes there is no application for leave for fresh evidence to be brought. 39. The MVDT's expertise was applied in assessing the reliability of the Land Rover given its age and mileage. 40. The respondent submits the MVDT took into consideration SS 6 and 7 of the CGA. In particular, under S7, 1, J, of the Act to have regard to all other relevant circumstances. 41. From the viewpoint of a hypothetical reasonable consumer, the respondent points to the 10,154 kilometers that the appellant had added to the mileage from the date of purchase until aspects apart from the transmission were raised. 42. The respondent submits the appellant had deprived himself of remedy because he failed to provide the respondent with a reasonable opportunity to repair. The attempts at repairs by himself and others are unsupported by documentation and raise the risk of defects being caused by inadequate or improper work being done on the Land Rover. 43. The respondent submits the decision of the MVDT was open on the evidence and on the law. Issues. 44. These issues for determination are as follows. A. In applying the CGA, did the MVDT fail to consider, or give inadequate weight, to the representations of the respondent? B. Did the MVDT fail to adequately assess or wrongly assess the evidence of defects in the Land Rover? C. Did the MVDT fail to apply the FTA, and if so, would an application of that act have led to a remedy favorable to the appellant? D. Was the hearing carried out in a way that was procedurally unfair to the appellant which prejudicially affected the appellant's position and the result of the proceeding? Discussion. 45. The MVDT decision does not specifically address the statement but he goes perfect, this being said by the appellant to be a representation of the fitness of the vehicle. The test applied was whether the vehicle was of acceptable quality from the point of view of a reasonable consumer who is fully acquainted with the state and condition of the vehicle, including any hidden defects. 46. In the present case, a defect was identified and remedied by the respondent. It is inherent in the MVDT's decision that the appellant continued to use the vehicle, did not seek to have the vehicle returned and obtain a refund because the vehicle fell below an acceptable quality. This was despite there being a defect identified and from the evidence produced satisfactorily remedied at that time by the respondent. 47. The decision of the MVDT takes into account, at least inherently, the circumstances that relate to this vehicle. The evidence produced indicates there was a pre-purchase inspection. It was suggested in submissions that there was a misrepresentation about the service history of the vehicle. The respondent made the point that the service manual for the vehicle was within the vehicle but that it had been completely filled and so additional service may have been possible, but because the record book was completely full, this demonstrated intensive maintenance and repairs had already been undertaken. 48. In addition, the appellant made the point that there was a false representation made in the statement 246 km with full history, one owner NZLII. I asked counsel for the appellant to point me to the evidence that this was an incorrect statement. I was not able to find any evidence that this was an incorrect statement of fact in the material provided. Counsel for the appellant was unable to direct me to any such evidence. 49. The representation made, although not considered in particular detail in the MVDT decision, appears to me to be subsumed by the more significant details which were described and form part of the reasoning. Those being that save for the transmission issue which was brought to the attention of the respondent and appropriately repaired, none of the other 5 alleged defects in the vehicle were provided to the respondent for assessment until some 10,000 kilometers was traveled by the vehicle. 50. I have referred earlier to reasoning from the MVDT 12 which I find no fault with. The findings in relation to work carried out by the appellant, or at his request, involve factual findings and credibility assessments. These were open to the MVDT. 51. My own consideration of the CGA and its application in this case mirrors that of the MVDT, and I cannot accept the submission made that there was an inadequate or incorrect consideration of the CGA within the decision. 52. As regards S9 of the FTA, this was a case in which the Land Rover was inspected by the purchaser. An indication of the running condition of the Land Rover was given. No evidence is present that this was at that point false. To an extent the respondent accepted that there was a difficulty with the transmission. This difficulty was remedied with appropriate repairs. 53. The appellant's case is that there was misleading and deceptive conduct concerning the Land Rover. The vehicle was a 2008 model having traveled 247,978 kilometers. Its purchase price was approximately $14,000. The standard which must be applied is that of a reasonable person who must be actually misled by conduct. The damage which is suffered must be caused by that misleading or deceptive conduct. 54. The gap in time between the original purchase and the application to the disputes tribunal, initially and then forwarded to the MVDT, shows a significant amount of use on the part of the appellant. This use included the towing of a boat and was accompanied by repair work either done personally or by a mobile mechanic. No timesheets, diagnostic information, or accounts were produced. The respondent points at intervening steps potentially damaging the vehicle, all occurring after substantial use by the appellant. 55. The expert opinion from the MVDT is effectively captured as set out above. 56. As regards the third issue as set out above, the MVDT did not consider the FTA. It is a matter of difficulty as far as the evidence is concerned for the appellant to establish that a reasonable person would be subject to misleading and deceptive conduct on the evidence as presented to the MVDT. The said representations must be set beside the obvious physical characteristics of the vehicle, the opportunity for inspection and the willingness of the respondent to repair a defect that was apparent. This was followed by continued use over an extended period, some 10,000 kilometers. All these factors make the application of S9 and S43 of the FTA highly problematic. 57. For the purposes of this appeal, reference to the FTA may be set to one side as being not available on the facts as presented. 58. As regards issue 4, the appellant was given a full opportunity to present materials both written and by way of oral evidence and submission. A right of reply was provided. The law, as I consider it to be, was applied fairly to an available set of factual findings. I see no procedural unfairness justifying me to allow this appeal. Conclusions. 59. The findings of fact and legal findings made by the MVDT were open and no error is discernible on consideration. 60. The defects with regard to the Land Rover were adequately assessed. 61. The non-application of the FTA was entirely understandable because the provisions of that act cannot be satisfied on the evidence as presented by the appellant. 62. There was no procedural unfairness in respect of the case which adversely affected the proceedings from the appellant's perspective. 63. The appeal is dismissed. I have considered the issue of costs, and in this circumstance, there should be an order of $500 costs to the respondent. Judge D. Sharp, District Court Judge. Date of authentication 28/04/2025.